Hello everyone, I'm Brian Beamish, Ontario's Information and Privacy Commissioner. Thank you for joining us for this webinar. In the webinar, you'll get an overview of Part 10 of the Child, Youth and Family Services Act. In the hour, we hope to give you an introduction to the new requirements for child and family service providers in terms of the collection, use and sharing of personal information. And we'll talk about the new access and correction rights for individuals who are using those services. Our goal is to give you an introduction to Part 10 and to help get you ready for January of 2020 when those provisions will come into effect. We'll be starting with a recorded presentation that's about 17 minutes long. Following that, we'll be here for the remainder of the hour for a question and answer session. Joining me for that question and answer are two of our staff. Emily Harris-McLeod is on my immediate left. She is a senior policy advisor. And beside Emily is Sherry Liang. Sherry is our assistant commissioner responsible for tribunal services. Please don't hesitate to send in questions while the presentation and the Q&A session is ongoing. You can send them by emailing rvsp@ipc.on.ca. That address should appear on your screen. We have around 400 people joining us for the webinar. We will try to get to as many questions as we can, but please do send the questions in. If we're unable to get to the questions, they're still very helpful for us to understand the issues that we need to explore and address to get ready for January of 2020. Please remember that your questions are anonymous. If we use your question, we will be not reading your name over the air, and the other participants, the other viewers, will not see them. Following the webinar today, we will be posting the webinar to our website and making it available through our YouTube channel. So with that, let's get underway, and Sherry, Emily, and I will see you after the presentation.
Welcome to our presentation on Part 10 of the Child, Youth and Family Services Act. Part 10 creates a new access and privacy framework for personal information held by service providers in the child, youth, and family services sector. In this video, we'll provide an overview of these new rules, which take effect January 1st, 2020. In the next few minutes, you'll learn about the new privacy and access rights for individuals when it comes to their personal information, and the new rules service providers must follow when collecting, using, and sharing their clients' personal information. But first, a bit about us. The Office of the Information and Privacy Commissioner of Ontario, or the IPC as we like to call it, oversees the province's privacy and access laws. These laws govern how Ontario's healthcare sector, public institutions, and child, youth, and family service providers collect, use, and disclose personal information. Our office educates public institutions and service providers about what they can do to keep personal information private and secure. We also respond to complaints from individuals with concerns about how their personal information is being collected, used, or shared, and complaints from people having difficulty getting access to government information and their own personal records. To learn more about us and our work, visit ipc.on.ca. Part 10 of the Child, Youth and Family Services Act creates new rules around access and privacy in the child, youth, and family services sector. If you are providing services to children, youth, and families, you may be wondering, do these rules apply to me? In general, Part 10 applies to service providers who are funded or licensed under Ontario's Child, Youth, and Family Services Act. These include Children's Aid Society, group homes and foster care agencies, those licensed to provide adoption services, and those who provide other services funded under the Act. It is important to note that foster parents are not considered service providers under this law. In some cases, service providers may already be subject to one of Ontario's other access and privacy laws and exempt from many of the core rules of Part 10. For instance, if you are a healthcare provider, Ontario's Personal Health Information Protection Act applies to the collection, use, or disclosure of personal health information, and not Part 10. Or, if you work for a provincial or municipal institution, like an Ontario government ministry or a municipality or school board, the Freedom of Information and Protection of Privacy Act, or its municipal counterpart, applies. Even if you are already subject to one of Ontario's other access and privacy laws, a few sections of Part 10 will still apply. These sections concern things like sharing personal information for planning and managing services. For more details on these sections, consult the IPC's Guide to Part 10, which is available on our website. The rules of Part 10 apply to personal information in the custody or control of a service provider that relates to the delivery of a service. But what is personal information exactly? It is any information of a personal nature that could be used to identify someone. It can be found in paper records, electronic records, photographs, and video footage, or in information collected during a phone call or interview. Even if it doesn't include a person's name, a file or record can contain information like age, education, gender, or medical history. Alone or combined with other personal details, this information could be used to identify someone and must be kept private and secure. In most cases, service providers must have an individual's permission to collect, use, or share their personal information. The individual, or someone who is allowed to make decisions for them, must give this permission voluntarily and directly. A person of any age can give, withhold, or withdraw consent for the collection, use, and disclosure of their personal information, as long as they are capable. Service providers can assume an individual of any age is capable, unless they have reasonable grounds to believe otherwise. To be capable means that the individual understands the information related to deciding whether or not to provide consent, and they understand the effects of giving, refusing, or withdrawing their consent. If someone is not capable of consenting, Part 10 lists individuals who can make decisions for them. These decision makers can give consent on behalf of an individual for the collection, use, or disclosure of their personal information, and can also make access requests for them. Parents with custody can act as decision makers for children younger than 16 years old, with some exceptions. However, in the case of a conflict, a capable child's decisions will overrule those of the parent. Individuals must understand the purpose of the collection, use, or disclosure of their personal information, how it can be used or disclosed under the rules of Part 10, and their right to give, withhold, or withdraw consent. Service providers can make sure clients understand this by explaining to them the reasons for collecting, using, or disclosing their personal information, and the ways in which it may be used or disclosed. They can also direct them to their organization's Statement of Information Practices that explains what information is collected, used, and disclosed, and for what purposes. This statement must be readily available on a website or in other public-facing materials like posters or brochures, and should be written in easy-to-understand language. It must include information about how individuals can request access or a correction to their personal information, and how they can submit a complaint to the service provider or the IPC if they have concerns about how their personal information has been handled. In some cases, it may not be possible to obtain consent from an individual to collect, use, or disclose their personal information. What then? Generally, a service provider is permitted to collect personal information without consent if it is necessary to provide a service and it is not possible to obtain consent quickly enough, or if the information is needed to assess, reduce, or eliminate a risk of serious harm to a person or group, or the service provider is a children's aid society collecting information from another society to assess, reduce, or eliminate a risk of harm to a child. Service providers can use personal information without consent if it's for the purpose for which it was collected or created. For example, an intake worker receives personal information from someone signing up for a service and then shares it with a case manager. As the information is being used for the purpose for which it was collected, to provide a service, the individual's consent is not needed to use it. Service providers can also use personal information, even if an individual has instructed otherwise, when it is necessary to assess, reduce, or eliminate a risk of serious harm to a person or group. They can also use personal information without consent for planning, risk management, or other activities aimed at improving or maintaining service quality. Service providers can also disclose personal information without consent in some situations, which include law enforcement investigations or cases where it is necessary to assess, reduce, or eliminate a risk of serious harm to a person or group. Children's aid societies can share personal information with each other or with child welfare authorities outside Ontario if it is needed to assess, reduce, or eliminate a risk of harm to a child. Personal information is sensitive and must be protected at all times to safeguard the privacy of clients. When thinking about how best to protect records, consider the sensitivity of the information they contain, the number of people in your organization who may need access to the records, and any potential threats or risks associated with how the information is being kept. Safeguards could include administrative measures such as privacy policies, confidentiality agreements, and training for staff. They can include technical defenses like passwords and encryption, or controlling access to locations where personal information is stored. No matter what protections are in place, they need to be reviewed regularly to ensure they continue to be effective. As part of their efforts to protect personal information, service providers should also have a privacy breach protocol in place. A privacy breach protocol details the steps to take if personal information is stolen or lost, or collected, used, or disclosed without authority. Key steps to take when a privacy breach is discovered include containing the breach by recovering and securing any information that has been disclosed and making sure copies have not been made, and changing passwords or shutting down computer systems to ensure other personal information is not affected. Service providers must notify individuals whose personal information has been compromised, and in some cases, they must also notify the Ministry of Children, Community and Social Services and the IPC. You can refer to the IPC's guide to Part 10 for more details on what to do when there is a privacy breach. Service providers must make sure that records containing personal information are stored, transferred, and disposed of securely. They must also have an up-to-date records retention policy. This policy should clearly set out the types of records the organization holds, categorizing them based on the sensitivity of personal information they contain, and stating how long records will be kept and how they will be destroyed. The policy should also explain how records will be stored or transferred if the service provider ends its operations. To learn more about best practices in this area, take a look at the IPC's video on records and information management, available on our YouTube channel. Poor records management can not only jeopardize the privacy of personal information, it can also affect an organization's ability to respond to requests for access to records of personal information. Under Part 10, clients of any age have the right to request access to records of their personal information held by service providers. Service providers cannot charge fees for these access requests and must respond within 30 days in most cases. Service providers are required to help clients with requests that do not contain enough detail to track down records. For these timelines to apply, and for clients to be able to file a complaint with the IPC, requests must be in writing. Service providers must also provide the IPC with annual statistics on the number of access requests they receive and how long it takes to respond to them. More details about the kinds of statistics to track and when to submit them is available in the IPC's Guide to Part 10. In certain cases, service providers can refuse an access request or only release part of a record. For example, access can be refused where another act or court order prohibits release of the record, or if the record contains legal advice. Service providers can also deny access if releasing the record could result in a risk of serious harm to someone, could lead to the identification of someone who was required by law to provide the information, or could reveal the identity of someone who has provided the information in confidence, and it is important to keep their identity confidential. If one of these situations applies, service providers can refuse access to some or all of the record. If an individual's request for access is refused, service providers must respond in writing and explain why they are not getting some or all of the records they asked for. This must include information about the individual's right to appeal the access decision by filing a complaint with the IPC. Hand in hand with a client's right to request access to their records is their right to ask for corrections to the personal information in those records. Under Part 10, service providers must make corrections at no cost, with certain exceptions. They can refuse a request to correct a record if the information is a professional opinion or observation made about the individual, if the record was not created by the service provider and they do not have the knowledge or authority to correct it, or if the service provider has reason to believe the request is frivolous or vexatious. In simple terms, a frivolous or vexatious request is a kind of nuisance request made for reasons other than obtaining access or correcting information. You can learn more about what makes a request frivolous or vexatious by consulting the IPC's fact sheet on this topic. As with access requests, service providers must respond to correction requests within 30 days, with a possible extension of up to 90 days. When a service provider refuses to correct a record, they must explain in writing why the request has been denied. In addition, they must inform the individual that they can prepare a statement of disagreement to be attached to the record. We've come to the end of our introductory presentation on Part 10 of the Child, Youth, and Family Services Act. Thank you for joining us today. We hope you found it helpful. If you'd like more specific information on these new access and privacy rules for the child, youth, and family services sector, download the guide to Part 10 from our website. Our website contains a variety of resources and guidance on access and privacy topics. You can also contact us for general information and assistance. We're here to help.
Welcome back, everybody. For the remainder of the hour, we'll do our best to answer questions. We've had a lot of really good questions come in so far. So Emily, Sherry, and I will take them and do our best with them. We had a couple of questions around a topic that really wasn't covered in the presentation, and that has to do with the IPC process for handling complaints. So the Information and Privacy Commissioner receives a complaint that someone feels their personal information has been misused or they haven't gotten access to their file. What is the process for us to deal with that? So maybe I'll start off by taking the first part of this. We have a three-part process for dealing with complaints. Initially, a complaint would come into our registrar and intake function. The intake folks are able to resolve a complaint and informally and try to find a resolution to it. They can also dismiss a complaint if they feel that it, for example, is outside of our jurisdiction. For files that are not resolved at intake, they go to mediation. And the mediator at the IPC will act as a neutral third party. Generally speaking, mediation is conducted by telephone. The mediator will contact the parties in turn, get their position, and try to find a settlement. I should emphasize that at the IPC, we put a great deal of emphasis on early resolution and mediation. Our goal is to resolve as many files as possible at the intake stage or at the mediation stage. And in fact, if we look at our numbers under the health privacy law, last year in 2018, we were able to close 97% of our files at either the intake or the mediation stage. So I think that's really important for service providers to keep in mind that our goal is to resolve early. If you have a complaint with the IPC or you find yourself dealing with the IPC on a complaint, please come to the table ready to resolve those issues and to look for a resolution that works for the complainant but also works for you. The third stage of our process, if we're unable to get that type of early resolution, is the adjudication stage. The adjudication stage is when the complaint goes to an adjudicator who can conduct a review and at the end of the day make a decision, which could include issuing an order. It's a much more formal part of the process. And Sherry, maybe I can turn it over to you. We had a question about how adjudication works. Is that a public hearing? Is that an oral hearing? How do we deal with adjudication at the IPC?
All right, so our adjudication process is typically done in writing based on written submissions from the parties. So when the adjudicator gets a file, they will usually prepare a notice of review which sets out the facts, the background, the context, the legal issues, and a bunch of questions that we want the parties to answer. Often this notice of review will go to the service provider against whom the complaint is made, and will give that party a chance to provide us with their written comments and answers to the questions. There'll be a back and forth. Once we get those written submissions, they'll be shared, unless there's something confidential in those, with the complainant. The complainant's submissions will then come in and we'll share those, if necessary, with a service provider to give them another chance to answer anything that was raised by the complainant. And at the end of the day, the adjudicator will then write a decision on the issues. Typically, decisions made at the adjudication stage that result in an order against a service provider, you'll expect those to be published on our website. When they are published on our website and an order is made, the service provider will be identified in that decision, but the complainant not. As Brian said, most of our cases do resolve before adjudication, so they are done informally. The resolution may be in the form of a letter, an agreement through a mediation report, those sorts of documents that don't get published.
Great, thanks very much. We have a question, and this is a question we've heard before today, and we know it's going to be an issue that many of you will have to deal with. If someone requests a record that your organization has, but was authored and provided by a third party, who is responsible for making the decision around access to that record? And Emily, maybe I'll ask you to answer that. And I guess a good example might be a police occurrence report that finds its way into a file. Who is responsible for making a determination, the access determination on those kinds of records?
Mm-hmm. I'm glad this question came in. This is a question we've heard a lot already about under Part 10. And the answer may be subject to some confusion, so I'm hoping I can clarify right now. So as long as the record is in your custody or control, then it would be you, the service provider, who would be responsible for providing access and determining the right of access, making, if there's a redaction that needs to be made based on an access exception, that would be your determination, even if you didn't originally author the record, as long as it is in your custody or control. So what does that mean? The idea of custody or control is in other privacy legislation as well. So some people listening today are probably really familiar with the concept, but if you're not, our guide to Part 10 goes into some more detail about what custody or control means. But I can highlight some main points about it. So first of all, the record would have to be in your custody or control. It doesn't have to be both. If a record is in your possession, so it's in your paper files, your electronic case management system, generally it would be in your custody as long as you have some right to deal with that record and you have some responsibility for its protection, then it would be in your custody or control. And a point that we've really tried to be clear on in our guide is that you can have custody or control of a record that you didn't originally author. So Brian gave the example of the police report that perhaps is in a Children's Aid Society file, or another example we hear a lot is about a group home that gets an access request, but some of the records originally came from the CAS. So again, it would be the person who had, or the service provider that had custody or control of that record, where the access request comes in, they would be providing access. But there's something I wanted to add here, because we have heard, and we do recognize there are going to be situations where the service provider who's received the access request, they think, I really want to consult with the original author of this record. Maybe it's the police or the Children's Aid Society. I feel, I need to consult with them to understand how best to determine the access rights. So does one of the exceptions apply? Could this result in a risk of serious harm? Was this information provided in confidence? They might feel they need to ask that author of the record. So can you do that? Yes, and there are a few ways you could do that. One is with consent. So going back to the group home example, a youth asks their group home for the records. The group home looks and determines that most of them are authored by the Children's Aid Society. They might want to speak with the youth and say, we're processing your access request, and it might be helpful for us to be able to speak with the CAS that wrote the records to help determine your right of access. Is that okay with you? So that's one route. But we recognize also that there might be some places where it would need to happen without consent. So maybe the police is a better example there. The CAS thinks, let's say there's a risk of serious harm to someone if this record is released, and they need to ask the police about that to help determine if there's that risk of serious harm to any person, then that might be a place where they could speak with the author of the record, the police, without consent of the access requester. And maybe just to add one more thing is, we know that this might, be some complex situations here. So this might be something that service providers want to think about in advance with some of their main kind of partners with whom they're sharing records. So if perhaps it's Children's Aid Societies and police, we know that they have local protocols with each other. That might be a place to think in advance, and in keeping with Part 10, how might we manage situations like this?
Great, thank you. We have a question around an issue that we, in fact, have a fair bit of experience with under the health privacy legislation, and that's the issue of unauthorized access, or what we call snooping, where an employee is looking at a file that the employee does not need to look at to undertake their duties. As I said, it is a persistent problem in the health sector. We have around, last year I think we had about 120 cases of snooping where hospital staff or medical staff went into the electronic health records of people they were not providing service with. So we know it's an issue, and we believe it will be an issue for the child, youth and family services sector as well. When you think of something like CPIN and people having access to CPIN out of curiosity or to people they're not providing service to. As we do with the health sector, we really stress there are a number of steps that need to be taken to prevent it. Staff training is really important to make sure that staff understand what their responsibilities are and aren't. There need to be clear policies and protocols in place to let staff know that they should not be undertaking this activity. We really stress staff training and the need on an annual basis, and the need to sign confidentiality agreements. And also, it's really important that there be some type of auditing of people's access, particularly to electronic records. We had a question around what do you do if you have a case of snooping. It's really important to contain the breach, to make sure that that person is not continuing to snoop, that their access is cut off while you're conducting an investigation. If you confirm that there has been a breach, there is a responsibility to notify the individual whose files has been looked at. There is a responsibility to notify the IPC and the ministry where there's been a breach. And I'm talking about where you verified that there has been an actual snooping incident. If someone has accidentally opened a file, looked at it for 5-10 seconds, realized they have the wrong file, we don't even consider that a breach. But if you verified that they've gone and spent time looking at a person's file where they do not have a right to look at that file, then you have a breach, and there is a duty to notify the IPC. And then, of course, it's really important to consider what additional steps you need to prevent that kind of behavior from happening in the future. I think the video did talk about the annual reporting requirements for service providers. So this is an example where you need to record that incident so that at the end of the year you're able to report back to the IPC in terms of the breaches that have occurred. We had an additional question came in. It's a good one around the retroactivity of Part 10. Do we have oversight over access requests that would have been made prior to January 1 of 2020? Is there a right to appeal decisions made prior to January of 2020 to the IPC? Emily, my understanding is that rights and obligations are not retroactive.
Right. Right. So an example I thought here is we often hear about people who requested a record and maybe they just got a summary back. Let's say they did this last year, and now under Part 10 there is a right to receive a copy of the file, not just a summary. So could they make a complaint about their last year's request to the IPC? And the answer would be no, because it happened before Part 10 was in force. So we wouldn't have oversight over that, but we would encourage people to say, you can make a new request now that Part 10 is in force, and then, if they were not satisfied with the response to that new request, then they would be able to make a complaint to the IPC.
Great. Sherry, we've had a question around if someone requests access to a record that also includes another person's personal information, so it may be their parents or foster parents, for example, does that have to be redacted in responding to the access request?
Not necessarily. It depends on a couple of things. First of all, if you receive a request for access, you would have to look at each record and decide whether the record is dedicated primarily to the information of the requester. And that is an important decision because depending on the answer to that, the requester may have a right of access to just the part of the record that relates to them, or they may have a right of access to the whole record. And the whole record may incidentally include information about other people. So that's the first important decision in that decision tree. Now, after you make that decision, the actual right of access will also depend on whether exceptions apply. So you would look at whether there might be a risk of serious harm to someone, whether you, by disclosing the information in the record, might reveal a source who was required by law to give information to you. So you would have to, you could look at whether those exemptions apply. So just to recap, the steps when you receive an access request would be, number one, compile the records. Number two, look at each of the records and decide on a record-by-record basis whether it's dedicated primarily to the information of the requester. And then three, once you decide whether you're dealing with the part of the record that is related to the requester or the whole of the record, decide whether there's an exception to their right of access. So just to give an example, a youth requests access to their service plan. And you decide that this plan is dedicated primarily to the information of that requester. So that requester presumptively has a right to access the whole plan. Then if none of the access exceptions apply, that person would have the right to get access to the whole document. However, if you do decide that there might be some serious risk of serious harm to someone whose information is in the record, you would be allowed to redact part of that. So that's how I imagine the request process would work for you.
Great, and that's probably a scenario that's going to happen quite often where there's mixed personal information in a record. We have a question here regarding the complaint process, and the questioner wants to know whether a person who has a complaint regarding a CAS record has to first go through the CAS's internal complaint process, or can they come directly to the IPC? I think the short answer to that is they have the right to come directly to the IPC. If they're asking for access to their record or correction of that, they of course have to go to the CAS first. They'd first put in a request to the CAS for access or for correction, and if they're unsatisfied with that response, then they have the right to come to the IPC. And in fact, the CAS would have to, in giving them a decision around access or correction, would have to notify them they have the right to come to the IPC. A complaint about, on the privacy side, that information has been misused or collected improperly or disclosed improperly would generally come straight to us. Having said that, I think we would encourage people to use the internal complaint process to try to resolve issues before they even get to the IPC. Just as we're looking for early resolution to issues, if it doesn't even get to us, that's probably a plus. Yeah.
Yes, and maybe I'll just add one thing about the access request, which is that there's nothing preventing a service provider from responding to a verbal request for access to records. But if an individual wants to have the right to appeal to the IPC from a refusal of access, then they need to make that request in writing. And as Brian said, the decision in response to that request in writing has to tell the individual that they have a right to bring a complaint to the IPC if the information that they're looking for has been denied.
Right. Good. This question is one that I'm sure a lot of service providers are dreading, if I can put it that way, and that has to do with what we call voluminous requests. You get a request that covers a large number of years or a lot of files. And how do you deal with that? Do you need to complete that entire access request within the 30 days that are spelled out in the Act? And what happens if you don't do that? And we're certainly appreciative here at the IPC that this will be a big issue. Some of these requests may be very large, may be very complex, and require a lot of time to respond to. And we know that resources are not going to increase to be able to do this. So we're very sympathetic to the situation you may find yourself in. The Act does set a 30-day timeline to respond, but it does allow for an extension of that for up to 90 calendar days. But that extension is just not, it must be based on the requirements of the Act, which says that responding within the 30 days would unreasonably interfere with the operations of the organization because of the size of the request, or that assessing the right to access is not feasible within the 30-day period. So if you do need to do some of the consultation that Emily talked about with a third party, you may be able to expand it beyond the 30 days. Keep in mind, though, that any extension beyond the 30 days is appealable to the IPC. I would emphasize on this, though, that just as we go through a mediation process when we receive a complaint, there's nothing wrong with an organization at the front end when they receive a large, voluminous complaint to try to mediate their handling of that. It's possible that the individual is asking for a large number of records, but really wants only a subset of those, or that you can negotiate a time frame to respond to a large complaint. There's absolutely nothing wrong with an organization having a dialogue with a requester right up front in order to try to narrow the scope of a request. Okay, Emily, the Act in many areas, or a couple of areas anyway, talks about serious harm.
Right.
And we have a question around how do you define serious harm. I think it's used in regard to disclosing information without consent. It's also one of the exemptions to access to a record where it might cause serious harm. How do we interpret serious harm?
Right. I'm glad this question came up because harm and serious harm are used throughout Part 10. So important things to know, they're not defined terms, so there is no set definition in the Act of what that means. And of course we haven't, our tribunal has not yet interpreted under Part 10. But there are some similar provisions in health privacy law, PHIPAA, and so I can talk about how the IPC has interpreted those. So first of all, it's clear that harm is not limited to bodily harm. So when you talk about harm, that can include psychological or emotional harm as well. The risk of harm can be to any individual or any person. There's some places where it talks about risk of harm to a child, and in that case it could be to any child. So for example, when in terms of the access exception that's based on serious harm, it wouldn't just be to the requester, it could be a risk of harm to any individual. And our tribunal has commented under PHIPAA that you wouldn't be required, in the event of a complaint, you wouldn't be required to somehow prove that releasing this information would cause serious harm. However, you would need to be able to show that the risk of harm was well beyond the merely possible or speculative. So you don't have to prove it, but you have to show that level of likelihood. And we may have already mentioned that in determining risk of harm, there is a permission in the Act to consult with members of certain colleges, so college physicians, psychologists, social workers. Any member of that college, if you needed to, you could consult with them in determining whether that access exception about a risk of serious harm applies. And that social worker, for example, wouldn't even necessarily need to work for your organization. If it was appropriate to speak with someone else who was a member of that college, you can do so. And the last thing I want to mention is actually we're planning to release a detailed fact sheet about not just that exception, but all the access exceptions that goes sort of into more detail about how to understand that. So keep an eye out for that in the fall.
Great. We have a question related again to processes at the IPC. And the question is there a prescribed timeline for the IPC to respond to complaints? And are there prescribed timelines for a complaint as it moves through the resolution process, or as it goes to intake, onto mediation, and onto adjudication? There aren't, and my recollection is the only time frame related to a complaint is that a complaint about access or correction has to be filed with the IPC within 6 months. But after that, there's no particular time frame for how the IPC deals with it. Sherry, I think we do have our own internal guidelines in terms of how quickly we would like to proceed.
Sure.
But I don't think we would move a file on from mediation if we thought there was a real likelihood of mediating onto adjudication simply because we hit a particular timeline.
Right. Well, first of all, the intake process is intended to be quick, and so we'll look for quick resolutions at the intake stage, whether it be consensual or we determine quite quickly that it's something that the IPC shouldn't be dealing with, it's outside of our jurisdiction, or in many cases where a service provider or a respondent under MFIPA, PHIPA, a health information custodian, or a public institution has reported a privacy breach to us. If we're satisfied with the way that they've responded to the privacy breach, we will try and let them know that quite quickly and close the file. When it goes to mediation, really the process there is in the control of the parties. Mediation is consensual, so if one of the parties is really not satisfied with how it's going and they want to go to an adjudicated decision, then they have the right to say, look, this is not useful, I want to move this forward. So the timing is going to be very much dependent on the parties' responses to how the mediation is going. Once it goes to adjudication, I did describe the process of the back and forth of getting written representations. So we have set deadlines. We'll typically ask the first party to respond to our notice within 3 weeks. And so we do have sort of some deadlines at each stage of the process. But in many cases, as I said, it's up to the parties and their willingness to engage in the process.
And one of the reasons why we want to mediate and not go to adjudication is that adjudication does tend to be a fairly legalistic process. We need to provide due process to the parties and procedural fairness. So adjudication is not going to happen in 3 weeks. It does tend to take a set amount of time to work a file through the adjudicative process. The presentation did set out the reasons why you can redact information in response to an access request, and we've talked about that a bit here in terms of being able to refuse access to information based on grounds set out in Part 10. This question, and Sherry, maybe I can get you to answer it, is if a service provider has denied access either to all or part of a record based on those exemptions set out, who has the onus of proof? Who has to prove that the exemption applies?
All right, so the onus is on the service provider, and that's the same under our public sector legislation and FIPA that apply to public institutions that have access obligations, and that's also the same under our health privacy legislation where people have the right to access their health records. So under the CYFSA, if a service provider has denied access to part or all of a record on the basis that one of the exceptions in the Act applies, then the service provider and the individual is not satisfied with that decision and brings a complaint to our office, then it will be up to the service provider to show us that that exception does actually apply, that it's a valid application of the exception. So, for instance, Emily was just discussing the exception for risk of serious harm. And let's say you have decided to redact part of a record because you believe that releasing that information will give rise to a risk of serious harm to someone. And this comes to the IPC because the requester doesn't believe that what has been redacted was legitimately redacted. So we'll ask you to explain the facts, the background context, why you believe that there is a risk of serious harm. We sometimes in our adjudicative process will ask for an affidavit to prove some of the facts that you want to show us. Other times we'll simply ask for your submissions, and if they are reliable and there is nothing to contradict them, we simply want you to explain your facts. We know the law. We know, we deal with the law, the act, the legal interpretation. We don't know your facts. So what we're looking for is for you to explain the basis of your exception, and that applies to any of the other reasons that you might deny access. So for instance, if you claim that there's a legal privilege that applies to the record and that's why you are going to deny access, then we'll ask you to explain why a legal privilege applies. If you deny access because you say that you compiled this record as part of preparing for a legal proceeding, then again, we'll ask you to explain what that legal proceeding is and why this record is related to that legal proceeding. So going back to the beginning of the explanation, the onus is going to be on you.
This might be a good time to point out that there is guidance available, or will be guidance available, on all of these legal interpretations or expectations of the IPC. Emily mentioned our guide. We do have a guide available already to Part 10. We'll be producing guidance documents on these types of issues as throughout the summer and the fall. Our decisions under Part 10 will be publicly available, and even now, our decisions under the health privacy law, PHIPAA, are available, and the concepts are really quite similar. Part 10 is based on PHIPAA, so issues like serious harm or onus of proof or application of exemptions, there is guidance available already, and there will be more to come. Another question related to retroactivity. The questioner wants to know, how many years can requests go back? Is there a time frame or a specific date? And is there a determined retention requirement? Emily, maybe I can throw this to you, but sure. My understanding is there is no particular time limit for people. People can ask for records going back to whenever, if I can put it that way.
Yeah, Part 10 is very clear. It says it applies to records whether they were recorded before or after Part 10 comes into force. So there's no specific limit. You could request a record from 50 years ago. That being said, I can tell that this question is getting at retention as well. So let's imagine a scenario where someone requests a record from you, from a community organization, let's say it's a service provider from 50 years ago, and your policy has been to destroy records after 25 years. That's your retention period. Then that might be the case, then you would have to let them know that and say, we have to deny access because we have only been retaining records 25 years. And so now, this is also getting at what are the retention requirements now that Part 10 is in force. So to be clear, there are no retention timeline set by Part 10. It doesn't say you have to retain your records for this many years, but it does say that service providers need to develop a retention policy. And it sets out what that policy needs to consider, and that it needs to identify the different types of records that you hold, and then it needs to identify how long you will retain them for. So starting, as when Part 10 is in force, each service provider will need to have this retention policy.
And I'm just going to jump in here and say that if a service provider responds to a request by saying that the records no longer exist, and the requester doesn't believe that, thinks that they haven't searched far enough, broadly enough, and that surely there are some records somewhere, that is a complaint that can be made to our office, and we'll look into that. And if we agree that more could have been done to look for the records, we can order a service provider to do another search.
Great, thank you. We have a question that came in around this issue of snooping and dealing with, I guess you'd call it retroactive snooping. If a service provider noticed that a staff person was looking at a client file they should not have been looking at, but it's from a couple of years ago, would that be considered a breach? And would they be required to report it to the IPC under the mandatory breach reporting requirements? And what should they do in these circumstances? I'm happy to hear what Emily and Sherry, you think, but yes, it would be a breach. They are accessing a file. If you've established that they are accessing a file that they should not be accessing, they have no right to access that file. It is a breach regardless of when it happened or the age of the file. And I can say from our experience under the health privacy law, quite often I use a hospital as an example, they will discover that a staff person has been snooping, and when they do an audit, they find that that snooping has been occurring for years. We would consider all of those breaches, and all of them would require notification to the individual involved, to the IPC, and to the ministry. And in terms of what they do in the circumstances other than contact those people, can only reiterate strongly the need for privacy policies, staff training and awareness, privacy notices and flags and confidentiality agreements. We do have some really good guidance on our website for under PHIPAA, setting out what to do about unauthorized access. So I would refer you to that. Sherry, I wonder if I can ask you a question around custodial parents. What access rights? Oh, sorry, Emily. Maybe I think this is probably up more your alley. What access rights do custodial parents have to children's aid records related to their children? And an example, though, would be where the investigation took place in another household involving their kids.
Okay.
What right would they have to those?
Okay. So first of all, a parent would always have the right to make an access request on their own behalf if they were receiving services, but I don't think that's what this question is getting at. So a custodial parent would have the right to act as a substitute decision maker for their child under age 16, and that involves being able to consent for collection, use, or disclosure of the child's information, but it also includes the right to make an access request on their behalf. So that's probably what's key here. So if it's a custodial parent, the child's under age 16, whether or not they're capable, the parent could make an access request on their behalf for the child's information. There's some important caveats here, though. So one is that there are a few exceptions of the type of records that it applies to. So private counseling information wouldn't be included. And another important caveat is that the capable child's decision would prevail. So the parent could make an access request on the child's behalf for the child's information. But if the child said, I don't want that, I don't want my parent to have access to my file, as long as the child's capable, then their wishes there would prevail. And then once the child is over 16, I should probably point out, then the custodial parent would no longer have that right. So 16 is the age where that changes.
We're running out of time. We have two more questions. Maybe we can try to get to both of them as quickly as possible. The first one relates to a child requesting records. And the service provider believes that the records contain information that might cause the child emotional distress or maybe traumatizing. How would those be handled? There are provisions that we've talked about that I think would kick in and allow a decision to be made about whether access should be provided or not.
Yeah, that is one of the exceptions where there's a risk of serious harm to the child.
Yeah, and it would be up to the service provider to substantiate that should there be a complaint to the IPC.
Yeah.
Right, and maybe one other thing to add there is just, maybe the service provider, if they do determine that it's not a risk of serious harm and the child, has a right of access to that information, there's also a question of sort of how and if they can support the child when they provide that access. So how are they explaining? There is a responsibility to explain when you provide access, about the record and give them the information they need to be able to understand that record, and maybe also to give them some information that would help support them when they receive that information.
We have a question around one of our favorite topics, one that we deal with both under the health privacy law and the province's public sector law, and that's around frivolous and vexatious requests. The question is there a limit to how many times a year a client can put in a request for access, and could repeated requests covering the same records be denied? And I think the quick answer is that the Act does allow an organization, a service provider, to call a complaint frivolous and vexatious. It's a fairly high threshold, but there are a number of indicia that we recognize would make up a frivolous or vexatious request. Pattern of conduct, putting in requests that are designed simply to be a nuisance, repeated requests for the same information. There are a number of reasons why a request might be called frivolous and vexatious. That designation, though, that decision is appealable to the IPC, and the person has the right for the IPC to review whether that request is frivolous and vexatious. We do have a fact sheet on our website dealing specifically with this issue. We are out of time. I want to thank everyone for joining us. It's been a pleasure to be involved, and thank you for your questions. I would note that there is already plenty of guidance out on our website. We have the guide, we have Q&As, and we will definitely be producing more over the summer and fall as we help you get ready for January of 2020.